bylaws. This seminar speaker is our FFO General Counsel, Mr. Charles Wang, a senior partner of a Washington, D.C. litigation law firm. And I want to give a very brief introduction on the background of Charles Wang. Mr. Charles Wang is the pro bono General Counsel of FFO. He is an internationally renowned lawyer and a legal scholar. He currently serves as a senior partner and the chairman of Asian Pacific Practice Group of a Washington, D.C. law firm. Before that, Ms. Wang was the first Asian American partner in the 200-plus year history of Cadwallader, Wixman, and Taft, the oldest and most prestigious American law firm that was instrumental in the establishment and the development of the Wall Street. As a legal scholar, Ms. Wang has been a keynote speaker at Harvard, Columbia, MIT, Duke, Johns Hopkins, and other reputable universities. An adjunct professor of both Peking and Tsinghua University Law Schools, a senior research fellow of Duke and Georgetown Law Schools, and the China Financial Policy Research Center. Ms. Wang is a recipient of Purdon Award of Legal Achievements in Association of the U.S. Library of Congress, and the past chair of Chinese American Lawyers Association in the Greater Washington, D.C. He received his Juris Doctor degree with honors from Duke Law School. So that is a brief introduction of Mr. Charles Wang, our legal counsel. So right now, let me pass on the microphone to Mr. Wang.
Hi, everyone. Welcome. And before I start, let me make a disclaimer. You know, that's my profession. I'm a lawyer, right? So this is a similar, consider me as like a professor having a discussion group with each and every one of you. So this seminar is not intended to provide any legal advice to any specific case under any state law or federal law, okay? One small correction. FFO was funded in May 31st last year, so it's not funded a month ago. We launched our website a month ago. Sorry, yes. Jason. I know what you mean. So let me start with, do you think you have right to fence? Most of the people, I heard a lot of people at the tournaments, I have right to do this, I have right to do that. I want to give you the first answer. No, you do not have right to fence. That sounds strange, right? Right, when we're talking about legal rights, right is the legal entitlement. Put it in this way, the deprivation or violation of the right, of your right, may give you a legal cause of action. For example, you have a right to self-defense. Fencing is not a right. You don't have the right to fence. It's not an automatic entitlement. It's a privilege. So what is a privilege? In the most simplistic way to say, it's really a benefit or advantage granted on certain conditions. So the conditions to fence in US, right? You fence in your backyard, nobody cares, right? If you fence in any tournament, you need to be a USFA member. That's the condition. As a member, you need to be abide by USFA athlete handbook. It's policy. So that's the condition. So now we know the difference. Let me give you an example of the difference between rights and the privileges. A student not admitted to a basketball team because the coach did not pick him up. He's too short or too weak. His heart cannot handle that the strength. Does that student has the cause of action to sue the coach? No, because to play in the basketball team is a privilege. He does not have a legal rights to play it. But if the coach did not pick him up, saying, okay, because you're Asian, now he has a cause of action because that violated his legal rights. Violation and discrimination based on race. So now, through this whole seminar, please keep that in mind. What is the privilege? What is the right? I feel a lot of, I hear a lot of fences, parents especially, get confused about privilege and rights. Then you said, okay, fencing is not my right, it's the privilege. What are the legal protections I have in fencing? When we talk about legal protections, usually we're talking about your legal rights. In the US, the three major categories of legal rights, right? You have contractual rights. It's basically negotiated under contractual terms. That's one right, right? Another category is common law rights defined by precedent, case law happened in the past, or through the common law tradition. And the third category is statutory rights granted by state or federal law. Jason just talking about a lawsuit. Actually, it's a confidential case. It's called a case filed under seal. So I cannot talk about any specifics about that case. I can talk about the law without referring to any specific facts in that case. Talking about lawsuit, let me put this, first. In my 25 years being a lawyer, I have always believed that lawsuit is the last resort. It should not be easily taken. Okay? It's not the most effective way, efficient way to solve a difference. So unless there is absolutely no other way, you don't file a lawsuit easily. And if you're not going to file a lawsuit, don't say it. You say what you mean, and you mean what you are going to do, right? And actually, it's not that easy to file a lawsuit, first of all. You need to have standing. I'm trying to, this is really not a law school discussion or a legal advice, so I'm trying to use very plain terms to talk about the very basic general principles of law and lawsuit. So first of all, you need to have standing, meaning, are you a qualified, are you a right plaintiff? For example, if I and Jason Liu were entered in the contract, and I breached the contract, and Mr. He Zhang is a good friend of Jason Liu. He is very mad at me. Okay, Charles Wang, how could you not honor your own commitment? Can he sue me? No, he can't. He's not a party to the contract. He doesn't even have the standing to sue, right? Secondly, you need to have a legal course of action. It's not every matter will have a legal course of action. For example, if somebody violated your rights, yes, you probably will have a legal course of action, one or another, and the federal law or state law or some contracts, right? If your privilege is taken, you lost the privilege because you do not, meet certain conditions. Do you have a legal course of action? You probably not. So you need to have the right course of action. And also you have to look at minimum the statute of limitation. How long can you set on a course of action before you sue? Every state has different requirements, different law about statute of limitation. Usually a civil course of action, 2 to 3 years. But child abuse is a lot longer. 10 years, usually it's 10 years after the victim turns to 18. Why? Because we care about our children. When they become adult, most of the time, a 19-year-old, 20-year-old still do not know how to protect themselves. So we give them another 10 years or even longer. They still can bring a lawsuit. And sexual assault adds even longer. Most of the states give 10 to 20, sometimes 21 years. You can bring a lawsuit. That being said, bring a lawsuit is never an easy decision. Don't take it lightly. There is another law called frivolous lawsuits. If a lawyer bring a frivolous lawsuit, the court can sanction the lawyer. Reprimand is probably the lightest sanction, or suspension for a certain time, take your livelihood away. And most lawyers are useless if they cannot be lawyers, right? So if the license is taken away, so they are kind of doomed. To the most serious violation, they could be disbarred. So let's say, okay, Jason is my friend. He come to me, Charlie. Somebody really pissed me off. I want to sue him. I look at the facts and say, Jason, there is no cause of action. I'm going to double your hourly fee. I'm going to pay you $2,000 an hour. Just to file a lawsuit for me to scale that son of gun. Will I do that? No, definitely not. No matter how good a friend he is. Because if I do that, I risk lost my license. Basically my livelihood. So I heard people in our fencing community like to threaten, okay, I'm going to sue you this, I'll sue you that. As I said, only say things you mean it, and only say things you can do it. Don't throw those lawsuits, those words around empty. Those are empty words. Okay, and also if you're a fencer, you're a coach, you're a club owner, your parents, somebody threatened to sue you, you first make sure, you get legal help, whether that's just a threat or whether the other side really has a course of action. If there is no course of action, don't worry about it, sleep tight. There's nothing, every licensed lawyer will think about this. If they bring a frivolous lawsuit, they get, themselves in trouble. Now, let's we put that outside of the way, and now we're talking about rights, right? Contractual rights, the easiest form. Contract is a party negotiated agreement that defines each party's rights under the certain contract. There's no other rights outside that contract except those the law specifically provides, like statutory, common law rights, all those. So when you have a written contract, read it. My first advice to everyone is read it before you sign. Because in the written contract, the written terms control. Maybe in certain cases, they are other argument to invalidate a written contract or to go beyond the terms to ascertain, the contractual intent, the meeting of mind. And sometimes there were, arguments about fraudulent inducement, unconscionable terms, also, lack of capacity to execute the contract. I'm not going to elaborate that tonight. Usually that's not the case in the fencing community. But if you have a contract, before you sign it, read it, make sure you understand the terms. A more common phenomenon is a lot of clubs, they don't have contracts. They come, the coach and the fencer or the fencer's parents, they reach an agreement. That's still a contract, is oral contract. So for the oral contract, how do you define your contractual rights and the terms, especially terms? Okay, unless there is sufficient evidence to support otherwise. The duration of an oral contract is determined by the payment interval. If it's a monthly payment, you pay a monthly fee to use the club, that's a monthly contract. If it is an annual fee, that's an annual contract. Any party, coach, club owner, or the fencer, or the parents, they can terminate that contract or change its term unilaterally, okay? The other party can walk away, that's it. Other than that, there's generally no remedy, okay? Can I tell my coach, coach, last month you charged me, $60 and a private lesson. Why this month you charge me 70? Sorry, I just raised my price. No, you breach your contract. I did not, because every month you pay me monthly. That's only the duration of that contract is only 1 month. Unless there is a written contract stating, okay, for this year, my private lesson is $60. Then for that year, you cannot raise it. Okay. When our coaches and clubs and fans, parents understand all this, they will have less kind of disagreement, right? Another thing I'd like to mention a little bit, I don't want to go too much into the legal theory or tradition. We are, a common law system. Common law means case law precedents, but in the modern times, more and more, common law was codified in statute. The French and Germany, the civil law system, everything is by statute, by code, right? And of course, there's another system formerly called the Soviet bloc, the communist legal system is a whole different thing. But in the common law system, historically, there are two courts. Court of law. Court of law, you can only ask for damage. Yeah, your rights are violated. You sustain damage. Then your lawyer and the judge, will ask your lawyer how much that damage was. Everything is measured by what? By monetary damage. In a court of law, you can only ask for money back or, pay me my damage. There's another court called Court of Equity. Equity court can order the breaching party for specific performance. So in the fencing community, do we have that? Okay, yeah, I have this great coach, Andre Jiva, the great AP coach. He breached contract. I don't want him to pay me money. I want him to continue to train my son. Can you ask for that for specific performance? No, you can't. Anything you can have is okay. Yeah, he breached contract. How much money he needs to pay you? You cannot force a coach to specifically perform coaching on your kids. So, when coaches, why I raised this issue? The coaches asked me. The people said I have to coach the kids. I said no, you don't. Okay. They said they're going to sue me. I said let them sue you. They're going to lose. Okay. So don't worry about it. If some parents say, okay, I have a unlimited checkbook, I'm going to hire the best lawyer and sue you. You have to train my kids. Don't believe a word about that. No lawyer will sue in court for that. That's the contractual rights. And now there is another body of law called the torts. The law of torts is basically, before I go into that, actually this is related to contracts. Some law schools nowadays have a joint course. When I'm the old school, when I went to law school, there contract class and tort class. And now certain law schools have a course called contorts, contract and torts merged together. We actually see this all the time. You guys probably did not even realize when you get a tournament, you have to sign a waiver, right? A waiver or assumption of risk, all those is actually in a contract away certain tort liability. Assumption of risk is usually interpreted in the most broad way in sports because risks are inherent in sports. Okay, when USFA or clubs or venue, they're having a tournament, they all ask the participants to sign waivers. So there are certain forms, they have different names. Waivers means you waive your certain legal rights if an injury happens, right? Assumption of risk, you admit your you know there is risk involved, and you are willing to take it anyway. Release of liability is basically specifically say, okay, if this happens, the other party, USFA, does not have any liability. Or sometimes the even indemnity clause. The other party gets sued by somebody else. You agree to indemnify them, pay the legal fees, hire lawyers to defend them. But in the fencing community, usually for parents and club owners, usually is basically assumption of risk, release of liability, that sort of thing, or waiver, okay? When you put that assumption of risk clause in your contract, this is what most courts will usually uphold the contractual term on assumption of risk. Give it a broad interpretation. They will accept the parties' agreement on the release of liability, waiver of certain legal rights, indemnity, whatever you call it, unless the court view those terms are so unconscionable as to be expressly prohibited by law or against the public interest. Give you an example, a waiver stating that the student will waive his or her legal rights when they are injured as a result of the club owner's intentional, willful, malicious, or reckless misconduct. Will a waiver like that stand in the court of law? Probably not. That's way too much. But negligence, usually court will not even touch it. Yeah, you signed, you agree. Gross negligence, some courts even give some leeways to that. So that's why when you sign an agreement, be careful, read it before you sign your name. Okay, people will say, yeah, my club have a very broad assumption of risk clause. I don't want to sign. What can I do? Not much. Walk away, find another club. Can I sue the club owner? You cannot put something that broad. You can't. It's a contractual rights. Your right is okay. I don't know anything to a contract. You do not have a claim or cause of action against the club. And of course, the club owners, if they put a very, very broad indemnity waiver or assumption of risk clause, that really could amount to a something prohibited by law or something against the public interest. The club owner and the coach will have this risk if they are finally there is the injury happens unfortunately and he get challenged in the court. The judge may basically invalidate that clause. Says no, this is too broad. It's this is unconscionable. I'm going to hold you responsible. So the better way is do not go to either extreme. Find a lawyer in your own city and draft that clause for you. It's not going to cost you much. Another issue, I'm kind of just talking about different points. Most of those points is people asking me during tournaments or club owners. They know me. They have these issues. So I'm going to just throw it out. And after that, if you guys have any other questions, I'll try my best to answer in the most general way without giving any specific legal advice. Okay. Another thing is dealing with minors. How do we deal with minors? My best advice to you is don't talk to them, don't touch them whenever the guardians so demand. If the minor is opposite sex, never touch them. Okay? Another thing, don't get in arguments between minors other than breaking away a possible fight by taking your own child away. Okay? Not somebody else's child. I give you my own example. Okay? In a tournament, my daughter was talking with another fencer, a girl like a couple of years older So I don't know what they were talking. And then the other fence's parents come over to my daughter, and my daughter was like 10 years old, started yelling. Then I said, okay, that's a child, that's my daughter. You cannot talk to her like that. You can talk to me. Then both the coach and the parent start yelling at me, telling me to shut up, and still calling my daughter's name and all this. I said, okay, I'm not going to make a scene in a public tournament. I just took my daughters away. After I come back home, I have several choices. I can go to local court, issue a restraining order easily because, that's a man, grown-up man. This is a 10-year-old girl, right? And I can go to safe sport, Center for Safe Sport. Probably the coach will be suspended, and the parent, for a certain period of time, cannot go to any tournaments. Or I can report to USFA. Probably investigation will be opened. The same result. My wife has a very soft heart. So, it's only like a few minutes argument. You take our daughters away. Let's not do that, because if you do that, the coach get banned, suspended. There are a lot of other kids in the club who will not have a coach. And the parent, if he is banned from going to tournaments, then his daughter will suffer. So the kids are kids. I said, okay. I issued a cease and desist letter. I asked one of my colleagues in my law firm, send a letter. In a way, you guys don't want to get into that kind of situation, because if somebody really file a complaint, if you're a coach or if you're a fencer or if you're a parent, you may not be able to go to any tournaments for quite a while. So that's not worth it, right? If you have an issue, if children have an issue, let them work out. And also, in any tournament, you want to be your children's role model, right? Act as a role model, okay? So that's dealing with minors. The general rule is, okay, if their parents demand you not to do anything, okay, abide by that demand. Don't argue, because no matter when you go to let's say when the thing goes to a court, the judge does not care which side is right or wrong. You talked to a minor over the objection of the guardian. That action itself is wrong. You lose. So don't. Now, next area is people talking about a right to privacy, right of publicity. It's a kind of interrelated, two distinctively different legal concepts. Why this issue come up? Okay, your daughter is fencing with another one, like John He's daughter, great AP fencer. So he is basically video recorded. So other fencers' parents come over here, no, you cannot record my daughter. Or maybe a bystander, another child was playing and it was the background. Over there said, no, you cannot record. Do they have the right? Before I answer that question, there are several legal concepts we need to understand. The right of publicity is recognized as a property right, okay? Why is the property right? It's designed to protect the commercial value of the image that a person has cultivated in becoming a celebrity. It's really similar to copyright law, except this copyright is my face, right? Like Jordan, you need to pay him to call that Nike shoes Air Jordan. That's his name, right? Like absolute fencing, put that sign over there with Lee Kiefer's picture. You need to get their permission, pay Lee Kiefer. So right of publicity is a property right, okay? The right of publicity prevents unauthorized commercial, keyword, commercial use of an individual's name, image, or other recognizable aspect of the person. And This right is largely protected by state law, either common law, statutory law, whatever, state law. So about half of the states have recognized the right of publicity, only about half, okay? Not every state will recognize it. As a part of the right of privacy. They recognize right of publicity as a part of right of privacy. Okay? In other states, the right of publicity is protected through the law of unfair competition. So unfairly use somebody's image for commercial benefit. So, now, basically half of the states, the right of publicity is under the umbrella of the right to privacy. Another half is under the umbrella of unfair competition. So that being said, you know, state law differs greatly in the right of publicity. For example, in California, almost anyone, you don't have to be a celebrity, anyone's likeness, name, you know, image, signature, voice is protected for 70 years after the death. You know, now you guys know why Hollywood is over there, right? New York only grant rights to publicity protection to those who profit from the names and likeness. For example, in New York, I don't have a publicity protection because this face is not going to make me any money, or my name is not going to make me any money. So it's not a brand. Federal law, there are some federal law also provide protection, like the Lanham Act. The Federal Lanham Act provides protection where a person's identity is used to falsely advertise a product. For example, there's a knockoff shoes. It has nothing to do with Jordan. They say, okay, actually, Jordan not only endorsed Nike, also endorsed my knockoff. Okay, so that is against the federal Lanham law. To put it this way, you know, for the publicity rights, you need to be a celebrity like Lee Kiefer, and you know, in a very short future, like Jalen New, Jason's daughter, right? You will have that right. Most of the people, we don't. Now, another aspect of this, okay, videotaping convenience, right, is the right to privacy. That's a different right. A lot of people kind of confuse these two rights. Right to privacy is designed to protect the individual's personal right against emotional distress. Okay, it's not about property rights. The law of torts generally recognizes 4 types of invasion of privacy. The first type everybody knows is intrusion. Paparazzis. I guess everybody, especially celebrities, they hate paparazzis, right? Paparazzi come to my backyard to film my kids. That's the invasion of privacy. It's an intrusion, right? Appropriation of name and likeness. As I said, you know, if I start printing T-shirts to sell to teenage girls, I put Jennifer's name, signature, and her photo on that T-shirt for profit without her authorization. So that's not only violates the right of publicity, also it's a violation of privacy. The third one is called unreasonable publicity. There are a lot of this kind of case I'm not going to mention, you know, basically got a chocolate of cases. Publicizing one's private affairs. There is a reasonableness test. What is reasonable, what is unreasonable? When unreasonable is defined as the public has no legitimate concern. You publicize somebody's you know, kind of a affair with the neighbor. Does the public has a legitimate interest, legitimate concern? No. So that's unreasonable publicity. That's the tort. The fourth one, false light. basically defamation by false information. Anything if it's a truth, let's say absolute defense. If whatever you said is true, it's not defamation, okay? But you better be able to prove it true. If whatever you said is false, okay, you defame somebody's reputation, then you got the legal liability. Why all this are important to our fencing community, I will give you examples. Now, before I do that, let me go back to the videotaping scenario. Videotaping at the tournament, can you do it? The short answer is yes. But what about the right of publicity, right to privacy? There is another permanent right, it's called First Amendment, freedom of speech and press. The First Amendment protects the use by others of a person's name, image, likeness in limited scenario. News source, for example, they keep win Tokyo Olympics. Does a news channel need her permission to broadcast that event with, her fencing image video? No, there's no. It's for news resource, right? Educational material. Fred Wang videotape his daughter's tournament. Then ask coach then broadcast it to all the club members. Give comments why this action is right, why that strategy is not. Does the other fencer has any right to say, okay, yeah, that's my privacy, you cannot do that? No, you don't. Because that's educational material. And certain forms of entertainment even is allowed. The only caveat is what? There is no commercial exploitation by a third party. You make a video, you sell it on the internet, that's not okay. You do a video, ask your coach to review it for educational purposes, no problem, okay? Put it this way, the First Amendment of freedom of speech and press allows sources to include information and picture relative to current news item. So news, this neck, who won? It can be news, right? That's okay. Media presentation on public issue, which is kind of far away from us. Factual, educational, and historical material exactly apply to our tournament videotape. And the other category, entertainment and amusement, concerning some interesting aspect of individual like Justin Bieber, that's a whole different story. No relationship with us, okay? So the short answer is yes, you can videotape. And actually, without, if you do not use that for commercial purposes to make money, you put it on internet. As long as you cannot put USA Fencing's official video recording on your own YouTube channel without their permission. Can you post the video you video recorded during an act? Yes, absolutely. There's no invasion of privacy. You're in a public event, and those fencers, when they participate in a public event, you are using it for educational purposes with no commercial exploitation. Yes, you can do it, okay? Other question people raised to me is, what right, then tell me what right do you have in fencing? If it's a privilege, not a right. Yeah, don't confuse the two kind of word twisting thing, okay? You don't have a right to fence, it's a privilege. But when you fence, you do have rights. How? First of all, you have contractual rights, right? You become a competitive member. By contract, you're paying certain fees. you have the right to compete as long as your privilege as a member of USFA is maintained. You will not be expelled by violating its athlete handbook. Similarly, you're an access member. When you sign up as an access member, you have right to vote, right? So that right is not a privilege, that's a right. Nobody can take that away. If they do, you have a course of action. Okay? And you have all other statutory rights. For example, as the Asian member, you have Title VI right under the Civil Rights Act, which meaning, not to be discriminated based on your race. For those who are interested, I'm trying to avoid provide you citations of cases and the law. I remember this my first year of law school, trying to master that blue book citation form is a pain in the neck. But there are people who really want to know what those laws are. Okay, it's a 42 United States Code, USC, 42 USC Section 2000D at a sequential, basically a bunch of statutes give you that right. And as a female fencer, you're protected against discrimination based on sex under Title VII of the same act. And actually, the anti-discrimination based on sex, there's a lot more federal statutes too. Like Title IX of Education Amendment of 1972. That's another. For universities, schools, any school, they cannot discriminate you because you're female. And I will talk about now that protection is extended to transgender. Okay, it's not just male, female. I will talk about that specifically in a few minutes. And also Title VI, Section 504, and the 14th Amendment. When we say amendment, usually it's not amendment to a other law. We mention 14th, 1st, 5th Amendment means the amendment of the Constitution, the highest law on the land. So anything that is unconstitutional, even there's another statute says otherwise contrary to the Constitution, that law, that statute is invalidated as unconstitutional. So basically, the nation's highest law also protects girls, girls, boys, transgenders from discrimination based on sex or sex identity. So, and also the state law give you certain rights. Let's talk about the access member, right? USFA is a nonprofit organization registered in Colorado. So Colorado revised the Nonprofit Corporation Act, give USFA members right to access information. All those rights are intact. You have all those rights to protect your legal rights. So the only thing is you need to be a member of USFA. So that's a privilege. That's not a right. Okay. And also, in the U.S. legal system, right to due process has a paramount legal position. Everything, if you violate somebody's due process right, no matter whether the substantive law, that person, it's violated substantive law, irrespective of that, you cannot deprive him or her, his or her due process right. So, for example, the U.S. Congress enacted a law to designate the U.S. Center for Safe Sports as the national body with the highest jurisdiction on the safe sports matters. So for those again who want to, I don't have a PowerPoint slide. I thought this is really like a seminar, just like when I was teaching at law school, have a nice chat with a bunch of colleagues and the students. So that's why I don't have anything in a nice PowerPoint the presentation way. For those who want to look at it, you know, I encourage everyone. Anyway, any coach need to be safe sport certified. The code for safe sport is only 44 pages. It's really, you know, basically, you can just get a cup of coffee in a Sunday afternoon, glance over, you know, maybe 1 hour. That's all. It's very useful. I encourage every fencer, coach, club owner, referee, parent to read it. Okay. If you want to find the actual federal statute is Title 36 USC Section 2205 for 1 for the designation, and the federal authority is called the popular name is called Todd Stevens Olympic and Amateur Sport Act. It's also Title 32 USC 220501. Okay, the easiest way is ready to go to Center for Safe Sport, download it, it's free. Read it, you know, it's helpful. So you will know what are the boundaries, never cross the line. Okay, now, right to due process. This is the part I know Jason told everyone we provided resource support to a member to file a lawsuit against the USFA. You know, I would say lawsuit is just another way of communication. When all other ways of communication fails, okay, yeah, I want to get your attention, and I tried everything. There's no response. All right, you're violating my legal rights. I have no other choice of file a complaint. In this specific case, I cannot talk about the actual facts about this case, but I can tell you, you know, 2 months ago, as the pro bono counsel for this person, I sent my legal reasonings the email to USA Fencing. I find out, actually, this is another thing people don't like lawyers, okay? All my email, there's a read receipt, right? I found out this email was read this afternoon, 2:50. Finally, somebody at the USFA read that email. That's only because they were served by the federal court. I thought if they read that email earlier, probably, I hope, you know, I wish, we don't need to file a lawsuit. Now, I cannot talk about the lawsuit. Let me talk about the law without the suit, okay? The Center for Safe Sport has a well-defined process of initiating an investigation. People report with certain level of supporting evidence or witness. USFA, anyone reports USFA investigates. Whether that report is substantiated or not, they immediately. And I don't know how many of you received this email, disciplinary action, right? A bunch of fencers, coaches, or, you know, get disciplined. Usually when a code of conduct investigation starts, there is a thing called temporary measures. Temporary measures, before the investigation comes to a conclusion, there will be certain restriction on the respondent. In an investigation like this, we don't call them defendant, okay? It's not a lawsuit. On the respondent. The respondent usually is an athlete, is a coach, or a club owner, or a referee, right? Any temporary restriction on them, they call temporary measures, is going to somehow restrict this person's continuing endure in this sport. That's why it's called temporary measure. Right? The Center for Safe Sport, they place the temporary measures based on the graveness of the alleged misconduct and the necessity of such measure. And by law, the center, if the national governing body like USFA already issued a temporary measure, by law, the center will adopt the same temporary measure as its own. If the national governing body has not issued a temporary measure, then the center will decide whether they need to issue a temporary measure restriction on the respondent based on, as I said, two criteria: graveness of the alleged misconduct and the necessity, which I think is very reasonable to have those standards. USF, I don't know. USF usually will quickly issue temporary measures, open a reporting and the initiation of investigation. Okay. Another thing. Now, let's talk about due process right. Anyone can allege misconduct of anyone. Let's say Mr. Rich Rice is a coach. Okay? Some disgruntled students decided, I don't like you, to file a complaint. Without any investigation ahead of time, you don't even know who filed the complaint because, okay, we need to protect the complainant's identity. You receive a temporary measure. You cannot go to any tournament. You cannot go to club to coach. Is that fair to you? Definitely not, right? At least you need to have your side of the story heard. That's what the center and the code for safe sport provides. It provides the appeal process. You can appeal all temporary measures. I emphasize capital letter ALL, all temporary measures. And after the appeal, if the decision, the respondent is basically the one being restricted, right? It's not satisfied. Does that end over there? No. Respondent can ask for a arbitration by a neutral third party. Then that arbitration is pending. So basically, you have two chances to have your story heard before people actually can restrict you, which I think it makes great sense. USFA, no, unless the temporary measure is what? It's suspension. You are suspended from any coaching or any refereeing or any competition, tournament. You cannot appeal. There's no avenue for you to appeal. And there's no third-party arbitration. When you make a decision, then, yeah, you're doomed. That's a problem of due process, okay? In a court of law, you're guilty until, you're innocent until proven guilty, right? And the temporary measurements is not just restricting on a certain person. Take this example, okay? If I'm an athlete, if I'm suspended or I'm restricted, even just for 3 months, I could miss the whole season. If a coach, let's say a big club with, hundreds of students, the head coach is restricted. The whole club, athletes are affected. It's not something you just place on people without hearing their side of the story. That's a due process violation, okay? And another thing, when the Congress enacted the law to designate the center, the U.S. Center for Safe Sport, it gives the center exclusive jurisdiction on certain matters. And it also gives the center discretionary jurisdiction on other less serious matters. What jurisdiction exclusivity means? Basically, when the center issue a notice of jurisdiction, or the national governing body stop right over there. You do not have your own right to investigate. I'm sure everybody watch a Hollywood movie, right? This is like the feds go to LA police. This is a federal matter. We take jurisdiction. Basically, the local police, they cannot even touch behind all the evidence. The same thing. When the center exercise jurisdiction, national governing body, the only thing they can do is enforce every decision the center makes. But unfortunately, USFA's compliance office seems to not really understand this part of exclusivity. They will enforce certain decisions. They will not enforce other decisions. For example, the recent disciplinary email you will see, it's about a suspension lifted by the Center for Safe Sport on their former chairman, Evan Lee. This USA fencing happily, enforced. Okay, yeah, and he, the letter even stated the center has the exclusive jurisdiction. We have to abide by the center's decision. But how about an other person? They said, no. We have our own rules. We don't have to. So that's called arbitrary. Arbitrary enforcement. That is illegal. I say illegal is against the federal law. So when things like that, even though fencing is a privilege, right? When things like that happens, you have a legal right to challenge it, because this is not about fencing privilege. This is about your due process right. Now, we talked about the First Amendment rights when we're talking about videotaping. Now let's change to another topic. First Amendment rights is not absolute. Don't get it wrong. Because you have the freedom of speech and press, you can say whatever you want. No, you don't. Okay, unprotected speech during tournament, any hate speech, obscenity, speech inside kind of lawless conduct, or speech disturbing orderly tournament are prohibited, not protected by the First Amendment. The translate to plain English, don't yell at refs or anyone, even if your children lost the game point, 14 to 15, you lost, you think the ref is wrong, don't yell, don't shout. You do not have a First Amendment right to do that. Always be courteous, professional. Part of the game of fencing is to lose, right? So another unprotected speech is false statement of facts. Okay, it's okay to say, I think that ref made a bad call. That's your thought. You can say that. Nobody can hold you responsible if the ref, because you said that, not yet. I'm talking said. In a peaceful way, the ref give you any card. That's wrong. They do not have that authority. You yell is not what the content of you yell at the ref. It's the conduct of yelling. You get a card, right? So it's okay to say, yeah, I think the ref probably made a bad call. It's not okay to say that ref is corrupted. He must take money from the other fencers' parents. That's why he always make the other parent, one of the fans win, unless you have absolute evidence, substantiated evidence of corruption. When you say that on the ref, that's defamation, that's libel, that's slander. The ref has quite a few course of action to sue you in court. And probably the sport, we need to check that's whether a red card or black card offense. So do not say false statement. Do not use your speculation and state it as if it is the truth. Okay. And another thing, organizer can put out their own restrictions. You don't have a freedom of speech to go to church, go to Christian church to make antichrist speech, right? Maybe you can put a sign standing outside of the church in a parking lot, provided that parking lot is not owned by the church, otherwise you're trespass, right? So, to save my knowledge, okay, you go to a NAC to make anti-LGBTQ speech. Do you have that First Amendment right? You absolutely do not have that right. Why? USFA made it very clear. Diversity, equity, inclusivity, and belonging is its policy. DEIB is its policy. You're not satisfied? You don't become a member because that's a privilege membership, right? You want to make a change? You don't go over there to make those speech against LGBTQ, against DEIB policy. The right way to make a change? Yeah, elect somebody who can represent your position. Then you see the board, the democracies, with how many board member will support you, right? If the board make a change, that's a policy change, that's okay. But when the board already have a policy, you try to, have a protest, that's not the way to do it. As I said, you do not have the right. So we have to understand this. There are people for this LGBTQ. They should have the equal rights. They should be included in any competition. There are people thinking, no, I disagree. Whether you agree or disagree, going over there to protest or say something to harass a transgender is not the way to go. Okay, the right way is really find whether if you have enough representatives who are willing to make some change or accommodation of your view. Okay. As I mentioned before, I keep saying fencing is a privilege, not a right. So violating USFA's policy is the ground for discipline. Okay, which you do not have a legal right to challenge the sanction if you violated this policy. It's like you join this association by agree to abide by its policy, right? So know your rights, certain rights you can challenge. Others, if it's not right, it's not your rights, you cannot challenge. Okay, now another topic, I'm kind of jumping around. It's about retaliation. The people ask me, okay, I saw something, it's not right, but I do not dare to report because I'm afraid of retaliation. My short answer to you is don't be afraid. Why? Okay, let's talk about the law. Well, we'll talk about Civil Rights Act again. Okay, Title 7 of the Civil Rights Act prohibits any employer from retaliating against the employee who has made a charge or testified or participated in any charge of unlawful discrimination under the Act. So that also applies to membership organization. Okay, members. That same law applies. And another very dire reason for an organization not to retaliate is the financial liability. financial liability of the institution, the organization, and the personnel, the person retaliating, is much, much greater than the damage for usually for the substantive violation of the law that started the whole so-called retaliation chain reaction, right? Let me give you guys the landmark retaliation lawsuit. You guys can search it online. I'm not going to talk too much about it. It's a fascinating case. Okay, basically, an assistant athletic director and the two coaches complained of a Title IX violation to the leadership of Fresno State University, Fresno, Fresno State University. Okay, the resolution of the Title IX case resulted only what? An injunction asked the school to correct athletic inequality in sport program. That's it. Okay, injunction in your policy is wrong, change it. No monetary punishment. But when these two coaches and the assistant athletic director reported to the university, they were retaliated. They were retaliated, reprimanded, and made their life not very enjoyable at the university. You know how much the university paid this person, the whistleblower? $14.64 million in damage for retaliation. Okay? The actual substantive violation is basically injunction. You guys don't do this anymore, okay? Your policy needs to be changed. That's all. But the retaliation resulted in $14.64 million awarded to the three employees. After that case, every university, every association implemented its strict rule of anti-retaliation. I'm gonna put it this way, okay? Actually, talking about real retaliation, retaliate against who? Parents, athletes, children, or clubs. I have this much confidence on USA fencing, even though, I supported the lawsuit just filed against them. I have total confidence USA fencing in general, no matter what the fault they have, they would never do something like this because, they know the responsibility. Actually, the responsibility, the legal liability extends to person, not is extend to individual, not just the institution. So don't worry about it. Most likely, you see a problem, you report, either through, discussion, communication, the problem will be resolved, or to the worst case scenario, you have to, get people's attention through lawsuit. It will still be resolved in the courtroom and amicably in the, outside of the courtroom, amicably by settlement, or the judge makes a decision, both party abide by the decision, then be done with it. In my legal career, there are so many instances. I was sitting on the other table against a bunch of lawyers, right? At that time, I was a lawyer at the Catward, Wickersham and Toft, and we do a lot of capital market transaction. And another big law firm is Sherman Sterling. So we're fighting, in a hostile takeover, whatever. A few months later, we become co-counsels on another case. It happens all the time. So I know when people receive a letter from a lawyer, we were trained to, write in certain ways, right, to protect our client's interest. People get uncomfortable. It generates certain hostility. Yeah, this lawyer asked me, send me a letter, this and that. It must be threatening me, this and that. No, it's not threatening you. Lawyers don't threaten. Why we need to threaten anyone? Lawyers write a letter to express their legal position. Nothing more, nothing less than that. That's why I like to deal with people represented by lawyers. You know why? When a person is represented by lawyers, the other lawyer, they understand my language. I have no animosity against anyone. Okay, my client is my client. It's not, doesn't have to be my friend. And the other side is just, I'm protecting my client's legal interest. The other side doesn't have to be my enemy. Actually, I never make any enemy of anyone, right? So when the parties represented by lawyers, they see my letters, okay, this is just the standard language, okay? Something like, okay, procedural housekeeping rules, preservation of evidence, and also no ex-party communication. Now I'm representing this client. Please talk to me instead of reaching out to my clients. Why those rules are important? The two plaintiff or defendant, why they get in the fight? Because they do not understand each other, they cannot agree, right? The fight is already escalated to a lawsuit. Why let them keep fighting? Yeah, talk to me. Okay, your lawyer talk to me, and we're lawyers, we are professionals. We will not get into a personal fight. Then we exchange, our arguments, and a lot of times, guys, let me tell you, in the US, about 90% of lawsuits get settled outside of courtroom. Why is that? Because lawyers know which side has what right, and they will reach some kind of, mutual understanding. So, that being said, don't worry about retaliation. Lawsuit for us is another way of communication. There's no animosity or hostility over there. So, now I'm going to talk about some points. It's going to be it's going to generate some heat because some people are very, it's kind of two sides are, the middle ground are not much over there. Transgender policies for athletic programs. First, I want to say the transgender athletes in sports activity is one of the latest civil rights challenges facing all the educational institution and sports association. Okay, it's a civil rights issue. Okay, currently there are 33 state associations adopted formal policies setting forth anti-discrimination against transgender student athletes. Okay, and there are also guidelines governing the participation in school athletic programs. NCAA endorsed the guideline. You guys, if you want to go to NCAA's website, you can just type in, the title is called On the Team, Equal Opportunity for Transgender Student Athletes. Take a look at that guideline, all right? Before we do anything, say anything, whether for it or against it, you need to understand an issue and have a rational reasoning and all the social issues behind it. Do not let emotion take you to either side. That's what I can say. Nationally, that's about school, colleges, right? But for other sports, the USOPC let the national governing body decide its own policy regarding transgender athletes' participation. In the fencing community, USFA is a national governing body. It has the right, authority, let's put it this way, it has the authority to promulgate its own policy towards transgender athletes' participation. Both sides, for it or against it, you need to basically work it out at the policy level. Okay? USF already has this DEIB policy. Unless the policies change, I suggest everybody respect it. if you want to make a change, do not get in the fight on the strip or on the side of the strip. No. Okay? Because that's the fight you lose. That I'm telling you. And once you lose that fight, do you have a legal course of action? I already said it, no. You have no legal remedy. So unless that policy is changed, everybody should respect it. And if you want to make some changes, do it in the proper way, board representation. And to see, it's not a guarantee, okay? Yeah, you elect a board member who has a different view about the current USFA transgender policy. Does that mean it will change? No, because the body is, well, it's a voting process. One board member's position does not automatically change the organization's position, right? So you get the idea, don't fight a fight in a way you cannot win. If you want, you have some position, you want to do it properly. Last thing I want to cover is what are other authorities above USFA? Talking about law, right? Statutory law, federal law, state law, all those, that's not really above USFA. It's basically you have certain legal rights under those laws. For certain matters, the Center for Safe Sports we're talking about is above any NGB, national governing body. It's above USFA, it's above other, sports governing bodies, organizations, with a well-defined scope of the jurisdiction. Yeah, even though the Code for Safe Sports is a very short document, 40-some pages, but it will take me hours to go through those. So I'll take a pass, and maybe later on, if fencers, coaches, parents find this area of the regulation of law interesting, Jason can arrange for another seminar just to talk about the code for safe sport. So I'm not going to spend too much time to talk about that tonight. There's another governing body that's above USFA, USOPC, the Olympic and the Paralympic Commission. They have an integrity portal. Basically, anyone can report to that online portal or platform confidentially. You don't need to reveal your identity. You can report concerns to the USOPC regarding, a NGB's non-compliance with their own bylaw. Oh yeah, they violated their own bylaw. They violated the Todd Stevenson Olympic and Amateur Sports Act. They have some ethical matters such as conflicts of interest or governance matters. The members were not allowed to access the information, and the election is kind of there's certain irregularity. You can report everything. Okay, anyone can report any alleged employee misconduct of an NGB, code of conduct violation, you name it. Okay, and also, by the way, we're talking about retaliation. USOPC has a so-called speak up policy, which strictly prohibits retaliation against an individual who reports their concerns to them. The punishment is very severe. Okay, let's say certain management decide to retaliate the whistleblower. You know what? First of all, he lost the job. And if this is a systematic phenomenon, the organization could lose the Olympic, they lost the certification as the NGB. That's how severe the punishment is. And actually retaliating the individual authorized retaliation will have personal liability. So don't worry about that. Again, USOPC is another avenue. Fencers, coaches, club owners, parents can file complaint. If you can tell them your name. Usually, I would say review identity is better because people can collect evidence from you, interview you, and you have something to present, right? If you remain anonymous, yeah, people cannot reach out to you, don't know who you are. It's not going to help them to effectively or efficiently investigate whatever you report. So that basically concludes the areas people ask me to talk about. As I said, this is tonight is basically discussion about general legal principles, rights, privilege, this and that. It's not intended to provide any specific legal advice. In conclusion, as I keep saying this, you probably heard it 1,000 times. The fencing is a privilege, it's not a right, but you do have certain rights as participants. So violation of those rights will give rise to one or more legal cause of actions, which you can, bring it to the court. And I know USFA is in Colorado Springs, and either if a state law violation, you can bring it in the state law, state court. If it's a federal law question, you can bring it in the federal court in Colorado. And even if it's a state law question, because the members are scattered around all the states, you probably can still bring a diversity lawsuit into a federal court because parties are from different states. So again, I have to emphasize this: lawsuit should only be considered as a last resort. All right, because lawsuit costs money, cost resource, cost time. Another reason is, legal action lawsuits can protect the members' specific rights and amend a specific issue, right? Board representation is still the most effective way to make a system-wide progress for the betterment of fencing. So, to conclude my speech, in the upcoming election, vote for candidates who can truly represent you and who has the willingness to represent your interests and concerns. Only use people like me as the last resort. Okay? I'm happy to answer any questions. I don't know whether I covered whatever the questions Jason and all the executives from FFO collected. Any other questions? Let me know.
Well, thank you, Charlie. And well, I want to say something just to making sure everyone understands and who Fair Fencing organization is. And I think by now you can understand why we call ourselves a watchdog, to improve the fairness, the transparency, the professionalism, and the safety of the sports. So this definition is for a reason. We want a voice for the silent majority for this sports. And thousands of parents and hundreds of the club owners, hundreds of the coaches have not been treated fairly, have been historically ignored, have many things wanting to say, but don't have a channel to say it, wanting to seek legal helps, wanting to have an organization to back them up. Now here we are. This is why we are here. This is why we wanted to hear everyone's voice, and we wanted to see if it represents the vast majority of our members, and we will voice for you. And we will do that by first communicate it with the governing body, communicate it to the clubs, communicate it to another stakeholders. That's what we do. We encourage open dialogues. We want to talk first. Only we have run out all our communication channels, and if the things does not get resolved, then we escalate to the next step and the next step. Here is one thing: we are not afraid to take on to the step that above anything people ever heard and ever seen in this industry. So anything people have seen, have heard, and we are standing for it. If we think the cause is right, if it fits our members' interest, we are going to support it all the way. All right, so that's what I wanted to say as the president of CEO of this organization. And now we are taking questions, and I hope somebody, it's a Q&A session now. So if you have any questions, feel free to, I think, type into the chat, right? Hey, is that the case?
Yes, please type your question in the chat box. So far, no one.
Okay, okay. Well, I mean, that's, I think this is primarily a educational seminar. Let everybody understand our rights and our channel to fight our rights, right? So, and I hope, for me, I learned a lot. A lot of things I did not even know. I learned a lot. And if anybody and have a further on questions would like to drill down any of the areas that Charlie was talking about, this is the time. And otherwise, we are not going to have these kind of legal session or legal education session for quite some time. We will constantly, as a membership organization, we want to serve our membership. So we will constantly have seminars and in the next few weeks. Here's the next week, we are going to have another seminar. We invited a well-known and famous coach, foil coach, to talk about technicalities, talk about how to prepare for the NAC and what are the technical things we should do and how to prepare your kids to be psychologically ready, all kinds of the things. So it will be next week, and you will receive that from our broadcasting emails or the WhatsApp groups or whatever that the channels that we have, because we are trying to advertising on multiple fronts right now. So if you have the need, you can watch. You will see that, oh, maybe I am interested in this topic. So feel free to join. And then later on, we're going to have NCAA discussions on how we should expand NCAA programs, right, into more university, because that's, I believe, by far, this is the most concerned or the most important topic in many, many parents' minds. And here's one thing I want to clarify. This whole industry is all evolved about fencers. And parents is the financial backbone, by far the biggest financial backbone for this sports. So we need to hear, and being ourselves are parents, and some of them are coaches, some of them are referees, some of them are club owners, even including USFA. This ecosystem is all around fencers. Fencers are the people who perform the sports, and the parents are the ones to finance the sports. So these two, in my mind, are the most important stakeholders. Of course, coaches, clubs, referee groups, including USFA, they're all important. But in this case, we have to understand, who are we serving for? Who is our customer? I think that's an important concept for everybody to understand. And if you being a fencer, if you being a parent, you are the customer, because you need to have a voice. You need to have someone who can say something for you to represent your interest in the board. That's how we can make a board, a USFA board, a more representative of vast majority of the interest of everybody. So I guess I will stop here. And is there any questions? Type in the chat box.
Yeah, just to confirm the topic for next week.
Oh, okay. The tournament prep is the topic for next week. Yes, we're gonna cover a lot on how to prepare the JO, because we host the seminar 3 days before JO, before everyone fly out for the JO. So we wanted to have this seminar, and we call that the last minute practice, right? So this is one of those things that, although we don't do that on the strip, and because fencing is such a sport that needs to use someone's mindset and psychology, so a training of the mindset is also important, and we're going to talk about that in that seminar. So, well, I guess it's a quite group then. I know, Rich, you had some questions specifically on the case, and unfortunately we cannot talk about that specific case. Cannot talk about the details, but but Charlie has covered that at high level and from a legal perspective, legal and educational perspective. And I hope it answered your question. So. Okay, well, I guess that's, the legal set. That's different than any other, seminars we've done so far. And, I guess this is a serious topic. Obviously, this is a serious topic. And anything that related to the law and to the, lawsuit, it is. I have to agree. It is a very serious topic. And that's who we are, actually. Again, I wanted to stress the fact that Fair Fencing is a organization. On one hand, we are trying to help everybody to protect your own rights. That's one thing we do. Another thing we do is to provide services to vast majority of the membership. And the services including we do our best trying to, get the connections and expand the NCAA schools. And we try to, have technical discussions on improving everybody's skills on the fencing, even whether it's a foil, whether it's, whether it's a coach, whether it's a referee on that end. And we also, have services that including the college applications and college recruiting. We did that seminar last week. We will have a series of the seminar on the college recruiting and how to write a good college applications. So we probably from a general case to a more specific cases. And we also trying to launch our video review application and in a few months. And here is the thing. I see that I know a lot of people talk about the internet forums. And this is the opportunity for me to clarify it. We are trying to launch a video review application or video review system, by no means to challenging the current referees. And it is not for you to overturn a referee's call. And also it's not a way to look down or to criticize a referee. It is purely an educational platform so that we can have more experienced referees, more senior referees, or even a referee channel or panel to look at a questionable cause and then have a educated discussion to find out what the call, whether the call is right or wrong, and sometimes can provide advice on if you try to avoid those questionable calls, what should you do, what you should do. So this is the platform that we have been working on for months, and we hope to launch it in the next few months. And I think this will be a very useful tool that for people think that, hey, I mean, I think a lot of my calls is wrong, or my kids go fence always lose. And I think it's, should be her catch, not the other side, but why am I always wrong? So this will be opportunity to learn for both you, the parents, or the fencers, as well as the referees, because referees are human beings. They would make mistake. The best referees will make bad calls. We have to admit that. So we have to give them an opportunity to let them to know this call may be bad. They can look at the review themselves and look at the video themselves. And they can look again, I know this could be wrong. And this is the opportunity for them to learn. Only this industry, I mean, for us, only the kids, the fencers, the parents, and also the referees, we all have a positive attitude to learn from the things that we've done, and this industry can improve. And I think that the better, the more people like the sports, the more people knows the sports, then the more people will talk to others about the sports, then more people will join. That's how we promote the sports. And the fencing is a very undervalued sport. I see that it could have been much more popular than what it is right now. If you go to Italy, if you go to France, you can see that in the World Cup or in World Championships, all families turn on their TV stations. They are watching fencing. They are so excited. The fencers in the national team, they are treated like national heroes. They are icons. So I think our fencers and our national teams and this sports deserves much better in this country. And I think being a fencer or fencing family or fencing practitioner or coach or free, it is our goal. It's our dream and it's our duty to expand the sports, let more people know the sports, let more people to come and to play fencing, to do fencing, whether if someone wants to, or maybe more people to become a referee. I think that's also another thing. Our parents who have passion about the sports, him or herself, should learn to become a referee. And since you are going to the tournament anyway, that will be a cost saving thing. And you can contribute your knowledge and experience you have gained and in the tournament. I think that will be a win-win for all parties. Again, I mean, that's what FFO is for. We are trying to put all the stakeholders together and talk and finding out optimal solutions for everybody and let everybody has a say and we can communicate. It is unfortunately that we as a organization outside of USAFA doing this, but that's just the truth because our voice has not been heard. And for so many years, for so long, and this is something that we have to act because we know this is our sports. We spend thousands of dollars, tens of thousands of dollars. Our kids spend hours, days, years practicing on this sports. If we don't make it better, who else can? Right? We all have we should treat that sports like our own family business. And we are trying to pitch in and do our part to make fencing better. And that's what FFO is for. We are not trying to pick up a fight against any person, any organization, any club, none of this. But we are trying to protect people's rights. We are trying to voice everyone's concern, especially the silent majority who had no way of have themselves heard. This is what we are. We have to speak on behalf of all those little guys, all the ones that who are afraid to speak. And here, this is what we wanted to do. So I hope that over time, people can see the value from us, and we don't bother to respond anything negative things on the internet forums. And because I know that once we do a good job, once people realize our cause is right, once people know our management team are doing diligently and trying to make things better, people will view us differently. People will change. So I hope this is also an opportunity for me to can speak to the audience. And although this is not a seminar for FFO, but I want to use this opportunity to say such things. And by the way, next week, and we are going to have a seminar and a much bigger scale seminar, talk about most likely still online, and talk about our organizations and talk about why we established fair fencing, why we need to do this. So I hope that everybody had the time and that you're doing jail, and please join and to listen to what we have to say. Thank you.
Jason, there one more question from the chat box, and Charlie raising his hand.
Okay, sure. Charlie, can you see it or I have to read it?
Let me try to see it. Okay, you're talking about the video review. Okay, I understand both FIE and USFA has restrictions for one referee to judge another referee's call. Video review is not for one referee to judge another referee's call. That's people ask me this question. Basically, two fencers, when they are doing movements, actions, right? The referee on the strip made the call. Can another referee, or maybe many other referees, review this video based on the fencer's action, come up with their own determination? Yes. Any organization try to make that kind of educational analysis illegal or prohibit them, then that's illegal. Again, just like, we're talking about a violation of First Amendment rights, right? I don't think any organization is going to say, okay, no other ref can review a video in which a call is already made by a ref, because this video review, as Jason said, is for educational purposes. We have, the other ref have every right to do it. There is no legal issues for other ref to review a video and come up with their own determination. Okay, that's all I have to say.
Okay, I guess the question is a little different. I don't know if you're answering the same question. What I read was, have you been collaborating with the RC about this? I think RC means referee committee. And have we been collaborating with referee committee about this? What I know is that the similar concept has been raised, but it was not being taken in by the board or by the referee committee. And I personally have not talked to referee committee about this. I guess we will have a new referee committee very soon, or already had a new one. I don't know. I haven't heard it. It's just a way. It's a tool, and we will talk to referee committee about this. I hope that the USFA will adopt this as one of their educational tools, because I know that we have a very limited tools right now to improve the referees caliber. So I hope this will be one of them. And I hope this will be a good one, because people can learn from the real experience other than, just have a theoretical things about, what the rules are, and for each of the weapons. I hope this will be a good addition to the tools that they may already have, although I don't know really and what are the training tools that they have. I privately talked to many referees, and they did not give me a positive answer. They didn't think that there was many trainings or other tools that help them to improve. That's why we had the idea to build up such a platform. And this has been the thinking has been going on for quite some time, and we already have some prototype and a kind of a quasi working system, but it's not good enough yet. And we are trying to polish the system, and in the next few months, and hopefully that we can launch that. So yeah, I can see now the RC would love to have tools like this and the committee in place, but have limited funding and resources. Yes, we know. And we are not trying to blame anybody on this particular issue, because this we know have uh, a limitation. Those are realistic concerns, and we don't have enough funding for that. And it's not that easy to gather everybody. But see, this is the thing: we have technologies, right? The technology, the video review, and we have everybody has a camera. We have a lot of tools, and for everybody, for the referees to learn now, instead of having a junior referee go with a more senior referee, go to a bout and to watch, right? This will be a better, this will be a very effective tool. And think about all the parents who has a camera, or the fencers who has a camera and a videotaping everywhere, every day, every minute on the neck. And we have endless, data, more like endless data. Out of those data, some of them are questionable calls, and now we pick those things out and we'll review it with the senior referees, and help the junior referee to improve. I can see the referee committee would love to see this. So I am positive, and we will talk to the new referee committee about this, since the tool is not available yet, and we can have a demo to them and see if they like it, and see if they might be able to incorporate into a USFA official tool or something. Yes, definitely we will.
One more question.
Do you have senior referees sign up already? Yes. The short answer is yes. We have quite many FIE level referees sign up already, and we also have NAC level, the senior NAC level referees sign up already. Yes. And so what we, of course, we have to figure out, and in the beginning, and our organization is a nonprofit organization. Anything we do is not for any monetary purpose. Nobody. I mean, all of us are volunteers, executives, board members, all of us. So by referees, if they are doing this, and if a large volume of videos for them to review, then we cannot let referees do that for free. This will not be sustainable in long run. So initially they could, but we cannot do that in the long run. That's why USFA did not do it, because they have to have funding to do that. So we have to also figure out a way. But how do we figure out a way? And we have some pricing model, have some financial model in mind, I think it's fairly viable. So that's why currently the FFO membership is free membership, and it's in the future, and we have other membership category design, and you can pay a small fee, possibly can have certain number of video reviews, or you can do that pay by the go, and those kind of mechanism. We have that design in the mind. Of course, we have to test it with the market, and we have, of course, communicated with the committee and see if those things may work. So, right. Any more questions?
Jason, if you don't mind, I want to add a comment.
Sure.
So we have a video shared in our 300 people group. That video is regarding a very difficult call from FOIO bot. I'm an iPay fencer. I don't know FOIO. A person generously shared this video. A lot of coaches, referees, FOIO fencers, they give inputs.
Yeah.
As an iPay fencer, I learned a lot. I really enjoy the discussion.
Yeah.
No mention about if an iPay bot, how much I can learn. That's a true example.
Yeah, absolutely. Yeah, I watched the video. I gave my input myself as well. Of course, I'm nobody. I mean, not a ref, but I just it's a experienced parents, and a lot of fencers made comments, and the club, coach made comments, and referee made comments, and they are not the same, unfortunately. So, well, fortunately and unfortunately. So that is the tricky part of the fencing, especially in FOIO, and maybe in Saber as well. A lot of calls can go either way. It depends on the angle that the referee was looking at, and also maybe also the referee's preference as well. I mean, there are a lot of factors, and I think for our fencers, this is something that I think we tell our fencers. I tell my kids, and whenever people ask me, I will tell them too. This kind of questionable call is not the intention for the game. You try to avoid that questionable call. So why you wanted to do the same gesture if they are questionable? Why don't you use a different strategy? This is where that we all have to learn. And I learned how to way, when my kids lost, 14-15 at one point, and then the coach said exactly so. Why you wanted to let the referee, he could made a wrong call, but why? You could have done differently so that it's not a questionable call. It's your action made a questionable call. So that is something that I think for our fencers really need to bear in mind. And we are doing that, need to show our technical skills, and so that there will not be technical calls. I think this is true for many other sports as well, including basketball, soccer, and all that. So. Okay, well, I guess then this is a good almost 2-hour discussion, and if no more questions, then I would like to call on a day, and thank you very much for attending. This is the second seminar from Fair Fencing, and this topic was about the legal education and know your rights in fencing, and we have a lot more seminars coming up, and welcome everyone to join. And if you think we are doing the right thing, if you think our service is valuable, please sign up on fairfencing.org, and you can sign up, become a free member. If you think that we are doing something that it is a little bit helpful for you and the community, please broadcast the message and tell the people around you, tell the friends, tell other parents. And we are a non-profit organization. We have no agenda but to serve the community. So thank you all, and I guess have a good night, and we'll see you in the next session.
Good night.
Good night.